Good morning, everyone. Let's go ahead and call this meeting to order. Pierre, if you can call the roll.
Representative Brady,
Here.
Representative Breton,
Here.
Representative Chestek,
Here.
Representative Filer,
Excused?
Representative Kelly,
Here.
Representative Lee,
Here.
Representative Singh,
Here?
Representative Webb,
Here.
Chairman Washut.
Here.
You have a quorum.
Thank you. Just as a reminder, for any discussion that goes on the committee today, that we direct all discussion through the chair, that we maintain cordiality for everyone involved. I'm thankful for everyone who showed up today to express their thoughts on any of the bills that we're presenting today. And this in committee is where the public is able to get involved the most in the process of lawmaking. So thank you for showing up here today. Please respect one another. And the first bill for our consideration today is House Bill 194. Oh, I'm sorry, 195. 125. Let's get this straight. Yes, 125, repeal of unauthorized use of vehicle crime. All right, Chairman Washut.
Thank you, Mr. Chairman. Committee, I bring you House Bill 125. It's not very often that we get a chance to actually shrink the size of the green books, but today we're actually repealing a statute, so the bill itself is very straightforward. And I'd just like to begin with a story. So late one night, you're awakened by a noise in your driveway and you look out your window just in time to see your brand new $65,000 pickup back out of the driveway and disappear down the street. Pick up your phone, you call the sheriff and report your truck is being stolen. A deputy responds, takes your report, begins searching for the truck. A few minutes later, a deputy several miles away happens upon your truck being driven down the highway. He stops the truck and arrests the driver. Version 2. Late one night, you're awakened by a noise in your driveway. You look out the window just in time to see your brand new $65,000 pickup sitting on blocks and two guys tossing the last of your 4 tires and rims into the bed of their truck and disappearing down the street. You grab your phone, you call the sheriff to report your tires and wheels were stolen. A deputy responds. As she nears your subdivision, she spots the pickup with 4 tires and rims in the back. She stops the truck, and sure enough, these are your tires and rims, and she arrests the occupants of the truck. In version 2, the tire thieves will most likely be charged with felony theft of property. Okay, because these tires and rims are valued at more than $1,000. In version 1, however, the truck thief will likely be charged with a misdemeanor crime of unlawful use of a motor vehicle. How in the world can stealing the tires be a more serious crime than stealing the entire vehicle? That is what the basis of House Bill 125. So House Bill 125 repeals 3111-102, unauthorized use of a motor vehicle. Note that this statute is not in Title VI with all the other criminal code statutes. It's tucked away in Title 31 pertaining to motor vehicles. So the statute is problematic because of one word inside it, right? Any person who, without specific authority of the owner or his authorized or accredited agent, willfully, wantonly, or maliciously takes possession of, or drives, propels, or takes away, or attempts to take possession of, drive, propel, or take away a vehicle, the property of another, for the purpose of temporarily making use of the truck or vehicle, or who knowingly aids, abets, assists another in doing so, is guilty of a misdemeanor punishable by no more than 1 year incarceration and no more than $1,000 fine or both. Now compare that to the theft statute, 63402. A person is guilty of theft if he knowingly takes property of another without authorization. No mention of temporary, no mention of permanently, just taking possession of the property of another. When the property is valued at $1,000 or more, it's a felony. When the property is a firearm or livestock, it's a felony. no need to prove that there was a sense of permanent taking. So the unlawful use of a motor vehicle has a built-in defense for any criminal car thief. I was just using it. I was not going to keep it. Criminals have been educating one another about this built-in defense for years, and now it is rare when a car thief does not make a claim along these lines upon apprehension. By having to prove that the taking was not temporary, an additional element has been added to the crime when it involves a vehicle that does not exist when the item stolen has anything else other than a vehicle. So this does not apply to a thief who shoplifts a big screen TV. It does not matter that he was only going to use the stolen TV to watch the big game this afternoon and not keep it permanently. The fact that he took possession of the TV without permission and that the TV is valued at more than $1,000 is all that the prosecutor needs to prove. Likewise, this does not apply when a rustler takes a rancher's bull. The fact that he was only going to keep it while the bull temporarily bred a few cows does not matter. If you steal livestock, that is felony theft, period. In similar fashion, this does not apply if someone sneaks into your hunting camp, takes off with your rifle. The fact that he was only going to use it for a little while he killed his elk would not be a defense. He took your firearm without your permission. That is a felony every time. So why in heaven's name do we have a statute pertaining to the temporary taking of a vehicle? I don't know for sure, but I suspect sometime in the past, a legislator had a constituent whose son made a poor choice and pranked his rival by driving the rival's vehicle down the road and hiding it. The young man was charged with felony theft, and the legislator was called. Sensing a distinct difference between a car thief who wanted to keep the car and one who was simply pulling a prank, the legislator created this law to protect foolish offenders from being treated like professional car thieves, hauling cars to a chop shop for disassembly. Perhaps this was a laudable effort back in the day. Unfortunately, the existence of this law means that most car thieves today are being charged with misdemeanors and not felonies, or being allowed to plead to a misdemeanor under this statute in a plea bargain. The criminal law should serve as a deterrent to criminals, and the deterrent effect of our vehicle theft law has been seriously diluted. I hope that you agree with me that we are seeing some absurd outcomes because of this statute. These absurd outcomes are not necessary in order to avoid overly harsh sentences for pranksters or foolish offenders. Prosecutors today make charging decisions all the time, and they have more tools in their toolbox. They can decide at their discretion to not pursue charges at all. They can, when appropriate, handle the crime as a misdemeanor, or they might use a legal tool that's available today, Wyoming's deferred prosecution statute. I won't go into all of that. There are a couple of attorneys I know in the room that are going to testify about how this works on the ground in the prosecutor's office. So I ask you, committee, to please seriously consider repealing this statute, 3111-102, to better serve the people of Wyoming. With that, I'll stand for questions.
Committee, any questions? I have one. So, Representative Washut, and just in the simplest of terms, do you think that this bill grows government?
Grows government. I have a hard time imagining how that would be so. If anything, it's reducing the size of the green books. It's allowing prosecutors to make the correct decision, as they do with every other form of theft that doesn't involve a vehicle. I don't see in any way how that grows government. I don't think you need more prosecutors in order to deal with these thefts under the theft statute than you would need to deal with these crimes under the unlawful use statute. Potentially, you might convict a few more people of felonies that are going to go to your already existing prison. So I don't see that as a growth of government. And I think in the long term, the deterrent effect benefits us, and that quite possibly fewer Wyoming citizens become victims of car thieves once they know that this defense has been eliminated.
Thank you, Chairman Washut. Any questions? Representative Webb?
I'm just curious about if there's any, thank you, Mr. Chairman. I'm just curious to know if there's any concern with unintended consequences. Is this going to hamper law enforcement in any way? Things that have been thought through from that perspective.
Representative Washut?
Mr. Chairman, Representative Webb, I don't foresee that. I think this is, law enforcement's going to have all the tools they presently have for every other theft, whether that theft is anything other than a vehicle. I don't see that changing anything in that respect.
Thank you.
Any further questions? Representative Brady?
Thank you, Chairman. My question is, and I can I can understand your purpose for doing this, but why not just beef this up and make it a felony instead of a misdemeanors, rather than take it off?
Mr. Chairman,
Representative
Representative Brady, that would just be a duplication. We already have Title VI felony theft. Why would we create another felony theft statute? To me, it seems unnecessary to create a duplicative statute.
Any further questions? All right, thank you. Representative Washut?
Mr. Chairman, I have our district attorney and his chief deputy from our county here to answer any questions, tell you a little bit more about how this looks on the ground.
Excellent. Let's go ahead and have those folks come up. Thank you for being here. Please state your name for the record.
My name's Dan Idson. I'm the district attorney from Natrona County. With me today is my chief deputy, Blaine Nelson, also out of, obviously, Natrona County. I've been a prosecutor with the DA's office in Casper 25 years this summer. A lot of the questions that I heard asked of Chairman Washut, I think I can help answer to some degree. One from Representative Webb of, does this get in the way or does this hinder law enforcement, I believe was the question. And the short answer to that is no. You have to have the ability to sit across the table and explain to the victim why their car just got stolen and why that's going to be a misdemeanor charge. Representative or Chairman Washut, excuse me, is accurate. We have vehicles now that are $100,000. And somehow you can steal $100,000 and that's a misdemeanor. Not to be the old guy in the room, but that was more in my first house. Your body has moved forward in the years of really consolidating theft. Now we have fifth time theft is a felony. If you steal livestock, that's a felony. We now have, if you steal a gun, it doesn't matter the value, that's a felony. But you steal $100,000 and we're fighting over if it's a joyride. And frankly, victims don't understand that. That's a very hard concept for folks to get because they're making those big payments on their vehicles and you're telling them, well, that's a misdemeanor and a guy can simply get 6 months, $750 fine. And the idea that, well, that really doesn't happen isn't true. And it isn't true that it happens, to the bad people that leave the keys in the car, those things. It happens to us. I'm gonna run in and get a cup of coffee real quick. Leave your vehicle running, I'm gonna watch it, next thing you know, it's gone. The sheriff in Natrona County once had his car stolen from his driveway. His wife forgot her purse in the house, parked, went in to get her purse. And next thing you know, there's a high-speed pursuit through Casper. Ultimately, the car gets destroyed at an intersection in Casper. There's some other crimes associated with that that we charged, but nonetheless, that happens. People make mistakes, and I'm not even sure it's a mistake. You want to warm your truck up in the morning or your vehicle, and you do that. The idea of unintended consequences or the prankster, always remember, committee, everybody has to have some idea of criminal intent, mens rea, they call it. Some intent to commit the crime, not the intent to joke around with your buddy. And those are quickly ferreted out. And it's not the buddy calling law enforcement or calling our office saying, hey, our vehicle was just taken. We rarely see those cases. In fact, in 25 years, frankly, I'm not sure I have seen that case. Maybe if law enforcement sees it and the friend gives it up and goes, I parked it around the corner. But once it gets to the point where we're talking about, you don't see that case. You sat across that table from somebody that goes, 3 weeks ago, my truck was stolen and I saw it driving down the street today. And you're telling me that's a misdemeanor. Given kind of that procedural history and kind of where we've gone with our statutes over the years, to me, this seems to make a lot of sense to move vehicle theft over into theft itself. Truly, that's what it is. You oftentimes get what's called lesser included in jury trials. A quick example, sometimes you charge a major crime, say a first-degree homicide. A lesser included of that may be a second-degree homicide. If you charge theft, and we get creative at times and charge theft for a vehicle, we end up fighting this idea of a joyride. And we end up proving, as Chairman Washich said, or trying to prove, he really didn't mean to keep it. He just temporarily deprived him, whatever temporarily deprived means. So we're left with trying to argue, well, no, that's not true. And sometimes that, excuse me, is easy, right? They paint the vehicle or they do something to alter its appearance. But many times the folks just keep driving them. And that's where you run into trouble, and all of a sudden jurors start to get confused. I think what this does is gives law enforcement tools, gives clear direction to our jurors, but still holds criminals accountable. And when we start making that investment in vehicles that are six figures, we're serious about that as a state. I would be happy to stand for any questions.
Chairman Washington.
Thank you, Mr. Vice Chairman. Could you describe the other tools that you have in your toolbox when you have genuine mitigating circumstances and maybe a felony prosecution isn't appropriate?
Yes, sir. Thank you, Mr. Chairman. Ladies and gentlemen, we're fortunate, I think, in our system, at least in Natrona County, and I'm sure in other counties as well. We have options that we call pre-court options, that we try to intervene with students and specifically young people. Maybe we tell them to take a class thinking for a change, and if you successfully complete that, stay out of trouble. We don't file these cases. If it's maybe not your first rodeo, we have a youth diversion program, much like what you would think probation and parole would be, but for kids. The benefit of that is if you successfully complete that, we don't file that case. We in Natrona County have student court. Student court targets at-risk kids, not only at risk at failure in the educational system, but the criminal system as well. The hope is to get these kids a high school diploma and not come out of this with a criminal conviction. And if you complete that program, you won't have that. We have deferred prosecutions, as Chairman Washington spoke about, specifically Wyoming Statute 713-301. in that you place an individual up into 1 to 3 years of supervised probation. Should they successfully complete that, do what they need to do, that conviction is held in abeyance, and ultimately it's dismissed at the term of their probation. So we have these tools in place. And that's assuming we get there. You always have a level of discretion to read an affidavit and analyze that for criminal conduct. And then kind of make a decision based upon that. Talk with victims and kind of see what they think, where they're at. Was it 2 kids screwing around? Was it something more than that? And then go forward. Ultimately, you also have the tools to prosecute, if that's what's required. It's not simply an either this or nothing situation at all. I think we have a variety of things and stopgap measures that we have in place to make sure you don't have bad results, I guess is my point.
Thank you, Mr. Insum. Any other questions from the committee? Thank you. Mr. Nelson, do you have anything to say?
Yes, Chairman. And I was listening earlier, Representative Brady had commented on a question as to keeping the other statute and changing the penalties, but I have a comment on that if I may. One of the things that's important here is recently the state of Wyoming added that 63402 subsection J, which it means a 5th-time theft statute can be aggregated. So on your 5th theft, no matter what the item is, the prosecutor has the discretion of charging a felony. But one of the things that may happen there is that the joyriding statute is not included within that aggregate offense. So if someone were to be convicted of 1, maybe 2 joyridings, and we're moving towards that felony aggregated theft, we would not have the ability to use those prior thefts that were charged, prosecuted, and convicted under joyriding because they're not previous thefts. And so there is an additional value in consolidating this. And I think that was part of the intentional reformation that the legislature did in 2020 when they removed some theft statutes, combined them, and they also made things such as things that are reflective of both our values and our property interests. Livestock, firearms, those are important tools within our society, and they are also, particularly for firearms, a destructive item that has certain enhancements. That's why I think the legislature moved that. Consider the value of a motor vehicle. It is the tool in which most of us, almost all of us in a rural state such as this, make our way to work. It's the way that we are able to earn that living for several of us. And without this, we heard conversations about the loss of the wheels of a vehicle. That could be a felony. But what about the gentleman whose tools are in the truck? You can take the tools out of the truck, it's the felony there, but his vehicle, that is also part of that there, that is how he gets to that remote location to do that labor, that would not be the felony. And so I think by adding into 63402, livestock, which we have, firearm, which we have, and adding in to it the vehicle, we would make the unauthorized use of a motor vehicle redundant, and it would further help with that subsection J that the legislature thought that it was important to crack down on repeated thefts. Thank you.
Thank you, Mr. Nelson. Any questions from the committee? Representative Brady?
Thank you, Chairman. Sir, I'm sorry, were you just saying if this could be added to that statute?
There's 2 ways of doing this. The first one here is with the repeal, you can go through 63402A Roman 2, and then see right there, it's a valuation of the vehicle. So you would not need to do any amendments to the theft statute. The other option that could be done in there is if you were to add in just the one word of a vehicle, regardless of its valuation. That would make it clear that you could have a to-wit stealing of a vehicle is theft. But as it stands now, there is no need to have there is no need to amend 63402, our theft statute, in order to have vehicle theft successfully prosecuted in there. Repealing the joyriding essentially removes this alternative defense strategy by trying to undermine the deprivation element.
Any follow-up, Representative Brady?
What's that?
Follow-up?
Okay, so everything's in place and there's not going to be any confusion. It's going to include card theft and everything else, so.
Yes.
Because we have a lot of concerned people that there's not something in it, coming behind it in its place or, coming alongside it to remedy a repeal.
No, the repeal of 31 joyriding statute, the current theft statute here is effective at prosecuting this. It just removes what could be a lesser included defense that may be an exercise by some persons in defense.
Chairman Washington.
Thank you. So it's a practical matter. Almost every vehicle is over $1,000 in value today. That'd be quite the clunker to not hit that threshold today. We can't amend the theft statute in this bill, so it'd have to be a separate piece of legislation for next year. But just so we're clear, your testimony is that by repealing the joyriding statute, in the vast, vast majority of cases, we're going to be able to prosecute vehicle thefts as felonies, correct?
Yes, completely so.
Any further questions from the committee? Representative Lee.
Thank you, Mr. Chairman. Thank you for coming today. My question is, do you see a rise in vehicle thefts happening now?
Mr. Nelson,
Mr. Chairman, perhaps I could answer that.
go ahead.
Mr. Chairman, Representative Lund. I think historically, yes. I don't have the data directly in front of me, but I would say Casper Police Department, that's our largest agency in Natrona County, probably responds to vehicle thefts multiple times a week. And anecdotally, perhaps when I started, maybe once a month, something like that. Very rarely would you see that. But you're starting to see this ramp up quite a bit. Yes, ma'am.
Any further questions from the committee? All right. Thank you, gentlemen. We'll go ahead and move on to public comment. Let's start with the online comment from Mr. Tremmel, if he's available. He's being promoted. Okay. Mr. Tremmel, can you hear us?
I can hear you. Can you hear me?
All right, you're loud and clear. Go ahead.
Sorry, I have the wrong camera showing there. My apologies. Good morning, Chairman and Committee. Thank you for allowing me the opportunity to testify remotely today. Just a couple comments. I would like to testify in support of removing this statute. I think that the legislature has done a good job in their consolidation of the theft statutes overall, and I think by abolishing this, it goes in support of the previous testimony that was given by Daniel Litson. With that, I would stand for any questioning.
Any questions for Captain Tremmel? All right. Oh, Chairman Washington.
Captain Tremmel, can you talk a little bit about the frequency of the vehicle thefts in your community and how often those vehicle thefts tie into other crimes?
Sure. So just to give you some rough numbers, 2022, we had 124 report. 2023 was 154, and in 2024, it was 109. And so, all above over 100 every year, although, last year was a little bit lower than 2022. I would say that quite often vehicle thefts in general are tied in with other crimes. I think nationally, although it hasn't hit Wyoming yet, what you're seeing in a lot of other jurisdictions across the country are individuals that are committing crime steal vehicles in order to commit crime in order to cover up that criminality. And so, for instance, in the Northwest, there was an extensive study done related to solving violent crime, and one of the major recommendations was to target motor vehicle theft as a way to target violent crime. Luckily, you know, a lot of that hasn't transpired here in Wyoming, but it could only be a matter of time.
Thank you. Any other questions from the committee? All right. Thank you for your testimony, sir.
Thank you.
The next will be Chief Thompson from the Evansville Police Department.
Morning, Mr. Chairman. Mike Thompson, Chief of Police for Evansville. Just to reiterate, we're a partner agency with Casper, and a lot of times, you know, these vehicles that, you know, they take them. There's a certain group of people that typically, you know, do this type of stuff in its routine, and these cars get dumped in our territory, or we recover them. You know, bar none, mills, you know, as they flee, and these victims, you know, there was testimony earlier about these victims of these vehicles, and we, on our end, are the first ones that have to deal with this, and it's really hard. These people, you know, they're very emotional about their vehicles, and supporting the testimony that, you know, this is our livelihood in our rural Wyoming, and a lot of times they really don't understand that it's not a felony, and part of this process is to make these people whole. And how do you make them whole, you know, when you're having this amount of theft? So we take the blunt of it on our end. You know, the officers get, you know, the emotional reactions, and you know, it truly makes it easier for us to not have to deal with the unauthorized use, and I think it'll be easier for the public in the future. A lot of what I was going to say has been spoken, so I'll stand for question.
Thank you, Chief Thompson. Any questions from the committee? I just wanted to say that I understand the personal sentiment towards one's personal vehicle. I happen to name my vehicle, and so I'm not sure if everyone else does that, but I would certainly be upset if someone decided that they were going to borrow it.
No, I've never named your car.
No, thank you, Representative Kelly. All right, any questions from the committee? All right, moving right along, thank you for your testimony. Mr. Thompson, please.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, Wyoming Association of Sheriffs and Chiefs of Police. Our membership is in favor of this concept for all the reasons that were stated this morning. And if I may just kind of close one more, I think, question that has been posed today is, you know, why did this law exist? And if you remember the definition of theft prior to 2020, it said with the intent to permanently deprive the owner thereof. And that was a very high burden. In fact, in my 22 years of working during that application of the statute, I can remember our office only prosecuting one theft of motor vehicle, and that was because the person stole it and then traded it at a dealership. I don't know how he did that without a title, but that's the only theft, felony grand theft auto that I ever remember prosecuted in those 22 years. So with the changes in the theft statute, I think we're very well covered on any option that could come forward, and would support this concept today, and would answer any questions if you have any, sir.
Thank you, Mr. Thompson. Any questions from the committee? Hearing none, thank you for your testimony. All right, do we have any public comment on this bill? See no one in the room. Anyone else online? All right. Well, that being said, we'll go ahead and close public comment. Committee, what is your pleasure? Moved by Representative Lean, seconded by Representative Webb. Do we have any amendments? Okay. Hearing none. Question being called. Discussion on the bill. Representative Washit.
Just one final comment, Mr. Chairman. In 2023, there were 714 victims of motor vehicle theft across our state. And of those, only 413 of those vehicles were recovered. That means, 300 victims never saw their vehicle again, never had a ride to work, never had their tools recovered, never had personal possessions inside that vehicle recovered, just gone. And so anything that the legislature can do to add to the deterrent effect of our statutes to try to reduce the number of these thefts, I think is significant and important to the people of Wyoming. Thank you.
Thank you, Mr. Chairman. Any other discussion? Representative Lean? Any other discussion from the committee? I just wanted to say that, well, this particular bill hits home for me. My father had his car stolen within the last 2 years, and it definitely wasn't borrowed. And so thankfully it was recovered, but not everyone is as fortunate as to have their property recovered. So I think this is an important bill, and that's why I signed on to it. So if there's not any other discussion on this bill, Pierre, please call the roll.
Representative Brady,
Aye.
Representative Brett,
Aye.
Representative Chestek,
Aye.
Representative Feiler,
Excused?
Representative Kelly,
Aye.
Representative Lean,
Aye.
Vice Chair Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excused.
Chairman Washut?
Thank you, committee. All right, I'll resume the helm as we take up our next bill. Thank the witnesses who testified on behalf of 125. Obviously, there's a lot of interest in our next bill, House Bill 194.
I'm gonna step out for just a second.
Representative Lucas.
Thank you, Mr. Chairman. Good morning, committee. I appreciate the opportunity to speak to you today and to present House Bill 194 entitled Obscenity Amendments. I also did provide some amendments that I am recommending to this bill and really claim the newness of my position and my ever-increasing knowledge for needing to amend so quickly, and I appreciate your indulgence in that. Mr. Chairman, may I make a statement and then walk you through the bill?
Please.
Thank you. So a few years ago, parents and grandparents in Wyoming discovered that public schools and our public libraries contained books that had what we considered to be inappropriate level sexual material and content. We found them in junior high, high schools, even middle schools. Parents were never notified that these books and materials were in the schools and in the libraries, and I didn't expect a press conference, but they were really kind of covertly put in there, and the schools denied it, that there were any materials that were unsuitable for children. And I think that's really what we're going to be talking about, is what is suitable for minors to be consuming without their parents' knowledge. So over the past years, the local school boards have first said, we have no inappropriate materials. And then they said, well, you can opt your kids out of this stuff, but they never really removed the books. They were in easy access in school libraries and in some classrooms. And at our public libraries, they are on open display. And so parents would need to opt out, but other parents may not be aware of this and would never opt out. So then therefore, we have others making decisions for parents on what their children are consuming in terms of books and even movies. I've got a long list of what materials are in the bill, and we'll get there. So for now, I'm just going to say books because it's really easy. Our statute, our obscenity statute, has long prohibited the promotion of obscenity, and this is consistent with the Supreme Court's definition of obscenity for adults. The Supreme Court didn't develop or recommend language in their definition for children. I suppose we never really considered that this would be needed. The Miller test, which is taken from Miller versus California in 1973, has been used to define obscenity for adults, and it uses contemporary community adult standards. The Miller test does not speak to what is appropriate or harmful for minors. What consenting adults do in private is not the purview of this bill. The First Amendment does not incidentally apply to obscenity. The Supreme Court said that in their Miller decision. This bill adds definitions to clarify what is harmful to minors and what is obscenity with regard to minor children. You may hear today or in other places that parents and lawmakers who want to enact definitive legislation that protects children are called book banners and sometimes even homophobes, as labeled by some opponents of this bill. However, this bill does not single out any single sexual orientation or any sexual orientation or ideology. Adult-level sexual material or performances of any type are inappropriate for children. We have properly restricted minors' access to many activities and products over the years. So this is not something that is unknown. This bill does make everyone equal before the law, with the only exceptions being for law enforcement, judicial staff in the performance of an investigation, medical and psychiatric doctors, and parents. Of those in the exempted category, only parents have the right to decide what is appropriate for their children to read or watch. Parental control is local control. If there's no material that is harmful to children being accessed by children in schools and libraries, then this bill will not force the removal or replacement of any books. If a book is identified as containing content that is harmful to minors, then the book shall be removed from open access to minors. It'll be put in a different area, perhaps the adult section of the library, otherwise restricted, though, from access and view of minors. Interestingly, the schools have come up with what is called an identified list. Our school district here in Cheyenne has come up with that, and so they know what books contain the inappropriate adult level material. And so it wouldn't really be very difficult to pull those books off the shelves, pull them off the tables in the libraries, and put them somewhere else, so that if a parent wants their child to read this, they could do that. If it's not a problem in Wyoming, then this bill simply will fulfill our constitutional duty as listed in the Wyoming Constitution, Article 8, Section 20, to protect and promote health and morality of people. Mr. Chairman, when I present this walk through the bill, may I do that with my recommended amendments?
Yes, just make sure that we make it clear when we're talking about which, so
Yes.
that everyone's aware. I think a few people in the audience got copies of your proposed amendments, and others came prepared to debate and discuss the bill without those amendments, and so please make it clear.
Thank you, I will. So on page 1, it is a description of the bill. And so basically, we're creating a crime of promoting obscenity to minors. We're amending the definition, or amending the crime of promoting obscenity, and it'll be specified, providing and amending definitions for obscenity, repealing an exemption from the crime. And then there's an amendment prohibiting school libraries and county libraries from curating materials that are harmful to minors. And then there will be, of course, a discussion of what is harmful to minors. Let's go to page 2. Page 2 notes the Wyoming statute that applies to the crime of promoting obscenity, and that's 64301A, Romanet 1 and 2, and 6-4-302C, Romanet 1, and creating a new subsection, D through G. And let's go. Definition of disseminate is pretty extensive, although I think disseminate is a big enough word on its own that we could just describe that one. But basically, it's any methodology of providing content to children. There is an amendment which specifies unless an internet service provider, to the extent the internet service provider is not responsible for the creation of the material. We're looking ahead to try to avoid some unintended consequences. Material includes any form of human expression, communication, and includes, and then there's a very lengthy definition starting on the bottom of page 2A of what material is. And so it's basically anything printed, anything in digital format. That includes pictures, videos. It could be a device, novelty, recordings, transcriptions, telephone messages, recordings of telephone messages, whether it's live or pre-recorded, performances, live performances, exhibitions, transmission or distribution of any materials defined in subparagraph A. That live performance is further described that depicts nudity, sexual, and it's prurient nudity, okay? Nudity that is designed to instill sexual interest, sexual contact, sexual excitement, and so on. At the bottom of page 3, in the section 6-4-302, promoting obscenity and penalties. In the course of law enforcement, judicial activities, or in the course of medical or mental health care treatment. And then Romanat 3, I'm not sure about my numbering here, we may have to take a look at that. If the person is a parent or guardian, and the person is providing the obscene material to his child, or permitting his child to attend an exhibition of any deemed obscene material, if the child is accompanied by the parent or guardian. So the intent here is if your 16-year-old daughter is mature and you want her to be able to read The Handmaid's Tale, she can, with your knowledge and consent as a parent. But nobody else can make that decision for your child but you, the parent. Turning to page 4, I want to point out just a couple of words here. A person commits the crime of promoting obscenity to a minor if he, knowing the character of the material involved, knowingly, so knows about this material and knowingly provides this to a minor. That's part of the crime. If a person provides, invites, or promotes an event to minors that includes material that is harmful to minors, or transmits, sends, basically in any way provides this material to a child, a minor child, whether it's electronic or in-person physical material, knowing that it's harmful to minors. And then the penalty, which we didn't change this one at all. The penalty is the same as it is on the main portion of obscenity, punishable by a fine. It's a misdemeanor, punishable by a fine not to exceed $6,000 or imprisonment. Certainly not my intent to arrest anybody for this, but we just need to move these materials away. Page 5, harmful to minors is what we're going through now. And it's basically any presentation or promotion of materials that includes descriptions, language, in whatever form of nudity, sexual content, sexual excitement, sadomasochistic abuse. And then I have a lot of edits here, which is all deletion. And I had a lot of information here about relating to the Miller test as it applies to adults, and then realized that we're not talking about obscenity as it applies to adults. So I struck that language because we're not talking about what is obscene to adults. And what is obscene to children, obviously, is different. So that goes through page 5. And then we jump into page 6, which had a rather lengthy description of nudity. And I spoke with members of law enforcement and prosecutors who told me that, well, you know, every picture of a baby butt that gets put up on Facebook is going to be obscene. And even though those are not intended to be sexual. So I thought it would just be a lot easier to just get rid of nudity, so you don't have to worry if the statue, Michelangelo's David, is obscene, okay? So all of the nudity. And then we get into sexual conduct, which gets into a little bit of description. And then any other physical conduct with a person's unclothed genitals. And it goes into this, and it doesn't really, it's all there, rather clinical. And then any sexual or gender-oriented material that knowingly exposes minors to persons who are dressed in sexually revealing, exaggerated or provocative clothing or costumes, or are stripping, or engaged in lewd and lascivious dancing or movements, presentations, or activities in any place where minors are expected, invited, or otherwise known to be present. And we have seen this in some of our communities. And so some of those activities are not appropriate for children, and we know this, but we must put this out in plain English. And then a definition for sexual intercourse. At the bottom of page 7 is an addition that addresses libraries directly. No public school library or county library that curates collections intended for minors shall curate materials for minors that are harmful to minors as defined by section F Romanet 1 of this section. A person may challenge material as being obscene under the section by filing a challenge with the public school or county library. The amendment carries over to page 8. Not later than 60 days after receipt of the challenge, the public school or county library shall review the material to determine if the material is obscene by being harmful to minors in violation of this section. If the material is determined by the public school or county library under this subsection to be obscene, the public school or county library shall move the material from the minor section to an adult section of the library and restrict access by minors. We could entertain changing that "and" to an "or." I think either would be okay. Unless the minor's parents or guardians have provided permission to the school or library for the minor access to these materials from the adult section. And so bottom line is, parents get to decide if you want your children to read adult sexual content, you need to give permission for it. But it's not acceptable for all parents to be required to opt their children out. It must be an opt-in. And that's the bill, and I'll stand for questions. Thank you.
Thank you, Representative Lucas. Vice Chair Singh.
Thank you, Mr. Chairman and Representative Lucas. So I do have a question how this would practically affect our students. So this is specifically addressing the librarians and the staff of the school. I'm going on my 10-year reunion for my high school graduating class, and as I review my yearbook, there were some doodles that may have affected some of the language that is being discussed in this bill. So I just wanted to make sure that we are not putting our young people in a precarious situation with this bill.
Representative Lucas.
Thank you, Mr. Chairman. Mr. Vice Chairman, just to clarify your question, so are you asking if somebody writes something in a yearbook and it happens to be lewd, if that would be obscene? Perhaps it could be. I don't foresee that students in high schools are going to tell on each other. And I mean, certainly children do inappropriate things. They say inappropriate words. They write inappropriate language at times. And I just don't foresee that that's going to be an issue. Do they know that they shouldn't be doing that? Probably so.
Follow up?
Thank you, Mr. Chairman. Representative Lucas, would this bill make these lewd comments that our minors are making a crime against the state?
I don't foresee that. I don't think that is so, because we're not addressing what an individual activity rather than a course of materials that are provided to children in public schools and in our public libraries. I don't see that as a crime, but
Representative Lucas, just a reminder to
I'm sorry.
wait to be acknowledged by the chair and then respond through the chair.
I apologize, Mr. Chairman. Thank you for the reminder.
So on page 3 of your bill, you have a comment about recorded telephone messages. And I can imagine cell phone messaging back and forth between children, high school age children and so forth. So does the age of the provider, we had a previous bill dealing with adult transmission of information to children, but does the age matter here? Or are we, if a 17-year-old leaves a voicemail message that's fairly lewd, are we going to criminalize that with this bill?
Mr. Chairman, honestly, that's something that I had not considered. And I think that that would be worthy of some consideration and perhaps an amendment in the committee of the whole or by the committee.
Further questions by the committee? Representative Shestak?
Thank you, Mr. Chairman. I have several questions. I'm working from the version that the bringer brought to us with some amendments, and my first questions deal with the amendments. A lot of the people in the audience haven't seen these amendments yet, so please bear with me for.
Certainly.
I'm on page 5. So page 5, and this is, I think, the heart of the bill is defining what is harmful to minors, right? And the intent of the bill is to prevent things that are harmful to minors to get into their possession. You start off, the original bill as written defines harmful to minors starting on line 4 to be a broad category, and then starting on line 7, some exceptions. And the exceptions narrow that. So broad language, then narrowed by basically the Miller test, the prurient interest, and whether there's any social value, those kinds of tests from the Miller case. Your amendment deletes those, which broadens the category of harmful to minors. So the broad language stays, the narrowing language is being eliminated. So you're actually broadening the amount of the quality of things that will qualify now as harmful to minors. So now, and one of the things that is defined as harmful to minors is nudity, any form of nudity. Now, nudity that has these other qualities that are obscene in the original version might be accepted, but now they're not. Now, any form of nudity would be considered harmful to minors. And you do eliminate the definition of nudity starting on page 6. That also was, I think, intended to narrow it, but that narrowing, so any form of nudity now, according to this bill, would be obscene. I understand that your thought process on eliminating the definition of nudity might be to prevent the statue of David or the baby butts from being, but you leave the word nudity in the bill on line 6 without any definition or narrowing of it. So the amendments actually mean that the baby butts and the David statue that is nudity, and there's nothing to limit that. So I think it actually broadens it so that even that kind of stuff would be considered to be harmful to minors. Is the intent here to eliminate any kind of materials that could be used in sex education classes, for example?
Representative.
Thank you, Mr. Chairman. Representative Chestic, the page 5, line 6, the of nudity should be stricken. That was an oversight on my part in my zeal to get this in. I overlooked those 2 words, and it is not my intent to criminalize every form of nudity that exists. I have spoke with teachers and former teachers who have provided education, sex ed, if you will, and they have assured me that they're perfectly able to provide that education without any measure of lewdness or prurient interest, and by sticking with, medical, clinical terms, it seems to have been working just fine, and there really wouldn't be a problem with this.
Thank you. Committee, it's 9 o'clock. It's my intent to conclude public testimony today on this bill. We will work the bill separately on Wednesday. So keep that in mind as we ask questions and receive testimony this morning. We want to move through this material, give as many people as possible an opportunity to comment on the bill. Further questions for Representative Lucas? Representative Chestic.
Thank you, Mr. Chairman. My computer just shut off, so let me bring it back up. But I was concerned about one of the repealers, and I think you wondered why on page 3 at the bottom, why you went from 1 to 3, Roman at 3. That's not a mistake in the numbering. Roman at 2, and that's what I want to bring up here. Roman at 2 that exists in the bill, or exists in the current statute, says, so this section shall not apply to persons who produce, reproduce, possess, etc., material number 2 in the course of bona fide school, college, university, museum, or public library activities, or in the course of employment. So that's an exception. So those kinds of activities are protected by the current statute. But on page 7 of the bill, in section 2, C2 is repealed. So you are proposing to repeal the exception for bona fide school, college, university. So now, with that repeal, bona fide school, college, university, museum activities are not protected anymore. That's specifically why that's what the repeal does. What is the purpose of that?
Representative Lucas.
Thank you, Mr. Chairman. Representative Chestic, we have attempted for a long time to remove these materials from our public schools as parents and grandparents and community members, and from the library for open, easy access to children, and it hasn't happened. It seems that our folks working and providing these materials to children in these areas don't understand that what is appropriate for adults is not appropriate for children necessarily. And quite frankly, we've had very strong pushback on this across the state. And so when people knowingly provide adult-level sexual material to children that we've identified as harmful, perhaps maybe they shouldn't be able to make those decisions for children. Perhaps parents should be the only people who get to make those decisions for their children.
Representative Lucas, would you be open to retaining in Romanet 2 colleges and universities?
The only concern, Mr. Chairman, thank you. The only concern that we would have is that there are at times situations where minor children attend, for example, junior college. Both of my daughters attended LCCC as juniors and seniors in high school. And I suppose what I would like to see, just as myself as a grandparent and a parent, is parental consent. And with parental consent, then there should be no problem with that. And I would imagine that a parent has to consent for their child to attend a different school or to take a certain class. And I would be okay with that.
Thank you. I think that's the way the BOCES program works, is parents have to consent to be involved in those college and university settings.
Yes, Mr. Chairman, I think, just to add on, I think that children who are typically in that type of situation tend to be a little bit more mature, and yeah, I wouldn't see that as an issue.
Thank you. Further questions, Representative Lucas, Representative Bratton?
Thank you, Mr. Chairman. So Representative Lucas, so again, I'd just like to follow up on what Representative Chestick is saying in 64302C Romanet 2. I see that museum is also in there. Would you be open as we look at the bill between now and Wednesday and to also looking at that statute under museums? Have you considered that?
Representative Lucas.
Thank you, Mr. Chairman. Representative Bratton, I think that if a museum has a display that is sexually explicit and depicts some of the things that we have described here as harmful to minors, that parents would need to consent for their child to participate in or see a display like that.
Thank you. Follow-up?
Yes, have you seen any examples of that here in any Wyoming, or heard any in Wyoming museums?
I have not. Oh, I'm sorry, Mr. Chairman. I'm sorry.
Representative Lucas.
Thank you, sir. Mr. Chairman, Representative Bratton, I have not, but I have not been to every museum in Wyoming, so I can't really say I know that.
All right, thank you.
Vice Chair Singh.
Thank you, Mr. Chairman, Representative Lucas. So I was actually recently in Washington, D.C., and I was able to see the Holocaust Museum for the first time. And there were absolutely graphic exhibits there that depicted the realities of our history, but some of them displayed human organs. Are you saying that with this bill that it would require an explicit disclosure from the parents to be able to access that material?
Representative Lucas.
Thank you, Mr. Chairman. Vice Chairman Singh, I have also been to the Holocaust Museum in Washington, D.C., and it was probably one of the most traumatic and emotional things that I've ever witnessed myself. I do not recall that there were lewd, prurient, or sexual displays there, but there was nudity, and hence why I want to remove nudity from my original bill.
All right. Okay, do you have other witnesses that you've asked to be here today?
I have a number of community members who are here.
I'm sure we have lots of community
yes.
members. I'm just trying to see if there's any
No,
other. Okay.
I don't.
All right. Any elected officials in the room want to testify?
Chairman Bear.
Let's Chairman Bear, whoever wants to come up and testify, let's keep it tight. We're really up against the clock, and if we want the public to be able to testify, we need to keep that tight. So, any elected officials? Representative Brown.
Thank you, Mr. Chairman. I've taken a look at this bill, and after reading it, I find it incredible to think that we exempt libraries and librarians from the very laws that citizens on the street would be violating the law. They would be committing a crime if they were to do the same things around children. So I just wanted to say that when we look at these things, we need to keep in mind that just because someone is in a school setting, that doesn't change what is going on. When a child is exposed to obscenities, it's the same as if the person on the street is doing it. a teacher doesn't somehow have a halo over them because they have a teaching degree. And to allow these kind of things to happen, to expose these kind of obscenities to children is always hurtful, it's always damaging, and it will always be destructive to a child. It doesn't change just because of if the person holds a teaching degree, if the person holds the title of librarian. So I think these things are things we need to look at and we need to consider because it just doesn't change just because it's a different person. So I appreciate your time. Thank you.
Thank you very much. Further witness testimony this morning on House Bill 194. Keep it tight, because we got a lot of people behind you waiting to talk. So we want to hear what everybody has to say, but be on point, move it along very expeditiously. Please state your name for the record, make sure the green light's on, and tell us what we need to know.
Thank you, Mr. Chairman. My name is Lindsay Travis. I am the president of the Wyoming Library Association. I am here today speaking on behalf of our membership, which includes library workers in public, school, and academic libraries statewide. The Wyoming Library Association is urging a no vote on House Bill 194. We are urging this no vote for several reasons. First, the bill eliminates an exemption from prosecution for activities conducted in the course of employment at a school, college, university, museum, or public library. I would like to emphasize that librarians already take their responsibility for not promoting obscenity very seriously. We follow locally approved policies that dictate what is allowed in our collections. Books are shelved by their intended audience, by the age of their protagonist. However, even with the definition, individuals' opinions of what is considered obscene and what is considered harmful to minors varies. This is why the exemption is in place, to protect librarians and other professionals from frivolous and likely expensive lawsuits. The second reason we are urging a no vote on House Bill 194 is that this circumvents local policies. It is important to understand that in Wyoming, libraries are controlled locally. Public libraries are governed by boards of directors that are locally appointed by the Board of County Commissioners. School libraries are governed by locally elected school boards. The boards for both public libraries and schools are responsible for approving policies that outline what go into their collections. These policies are approved in a public process that allows for public comment. Importantly, policies for both public and school libraries include a request for reconsideration process, which allows members of the public or a parent to ask the library to reconsider having an item in the library. Policies already allow local boards to move or remove items. House Bill 194 circumvents this local control, local policies, and local processes. This would also lead to the removal of constitutionally protected materials such as health and sexual education materials. The third reason that we urge a no vote for House Bill 194 is that libraries already allow for parental control. This bill only grows government. Public libraries policies state that parents and guardians, not librarians, are responsible for monitoring the reading selections of their own children. Likewise, school district policies can allow parents to opt out their children from accessing library materials. The Wyoming Library Association knows that parents are best suited to understand the reading needs of their children. They understand their maturity levels and their own family values. We encourage parents to use tools already available to them to monitor library checkouts for their children. Those tools include parental consent for public library cards, the ability to link their child's public library card to their own to monitor their child's checkout, and the right that's already granted in a Wyoming state statute that allows parents and guardians to inspect library records for their minor children. And also, we encourage parents to talk to their librarians to help find materials that are appropriate for their children. It is for these reasons, as stated, that the Wyoming Library Association urges a no vote on House Bill 194. Thank you, Mr. Chairman.
So, Ms. Travis, a minor would not need a library card to peruse materials on their shelf. Is that correct? So that would take away that ability of the parent to monitor checkouts, but they would still have access to the material. Is that correct?
Mr. Chairman, yes, that is correct, that all materials are available in the library, but we do encourage parents to attend the library, especially the public library, with their children.
Representative Singh.
Thank you, Mr. Chairman. Director Travis, would this, would this bill prevent the sale of any of these materials on the open and free market?
Mr. Chairman, to answer that question, I'm not sure. I only know the library side of it, not the open market.
Fair answer. Representative Lean?
Thank you, Mr. Chairman. Thank you for coming today. My question is, some of these materials have been read at school board meetings and they've been asked not to read them. So my question is, what is the educational content of material that can't be read in a public meeting for a youth?
Ms. Travis?
Mr. Chairman, Representative Lane, I think it depends. The parental responsibility is what's very important when it comes to libraries. We require in a public library for there to be parental consent to get a library card. Policies are very clearly stated that it's a parent's responsibility. As for a school library, that the same thing goes, that the school districts can allow for an opt-out policy.
Further questions? Representative Webb, or Representative Brady?
Thank you, Chairman. Ma'am, excuse me, you were saying you encourage parents to come in with their children. Is there an age limit for children to come into the library?
Ms. Travis?
Mr. Chairman, to answer Representative Brady's question, it depends on the library. Not all libraries have different policies, so it just depends. Some have policies that state that unaccompanied minors can't be in their buildings, but some don't have that policy.
Okay, no follow?
Follow up?
Yes, please. So are the parents aware, other than having to read your policy, is it posted on the door somewhere? Because I'm kind of curious is if they can come in and peruse the books. You prefer parent, but how can you ensure if a minor does come in that they're not exposed to some of the books of concern?
Ms. Travis?
Thank you, Mr. Chairman. Representative Brady, most library card applications state that libraries do not monitor the activities of the minor children in the building. So that is given directly to the parents, and it is stated on the forms that they are signing in order to give them a library card.
Further questions? One more follow-up.
Thank you. So in my mind, I see this bill as a way to satisfy that issue without, because it's a public building, a minor coming in. I would think that this would take care of it if a parent isn't accompanying the minor. Thank you.
I think there was a question in there, not sure. Ms. Travis?
Thank you, Mr. Chairman. To answer that, I would state that it is the responsibility of the library board to put a policy like that in place.
Thank you. Okay, we're at 9:15. Sir, welcome. Thank you, Ms. Travis. Appreciate your association participating.
Mr. Chairman, thank you. My name is Dr. Ben Moritz. I'm Executive Director of the Community College Commission. We appreciate the spirit of the bill and definitely ensuring the protection of our children is everybody's concern. One of our primary concerns here was brought up to some extent earlier. If you look at 6-4-302C2, that was the exemption for colleges and universities for academic, I believe it was bona fide academic use. We feel that it's important to include that, to not delete that exception. We could give a lot of examples. I think for one thing, discussion that we're having here or the language of the particular bill could be questioned as something that perhaps we couldn't even include. And whether or not the nudity exception is included, the area of a library within the colleges and the university is intended for education, for post-secondary education. And it is true that dual and concurrent enrollment students or early enrollment students could, under the age of 18, enroll in a college or university and then therefore have access to this. However, a student who is under the age of 18, if they enroll in a college course, whether it be at the colleges or the university or anything like that, they do require parental consent to become a college student. And so having to separate adult-oriented materials from all of the other materials within a college library or the university library really is not logistically possible in a lot of instances. And so we would ask that C2 not be deleted from this so that the colleges and the university can continue to have effective libraries.
Thank you. Can you state your last name one more time for me?
Moritz. Excuse me,
Thank you,
Moritz,
Mr. Morris. I
M-O-R-I.
appreciate that. Questions? Representative Bratton?
Thank you, Mr. Chairman. Mr. Moritz, do you, would there be a possibility that when a student that was in concurrent enrollment could have, along with their, as they enroll, maybe have some sort of that you would provide some sort of a disclaimer or permission slip or just an acknowledgement that those materials are available in the college? Would that be something that would work?
Dr. Morris.
Mr. Chairman, Representative Bratton, thank you. That could be a policy adopted by the individual colleges. When a concurrent enrollment course is established, it's a relationship between the district and the college itself. And so those policies are established by those institutions rather than required by the commission. However, I believe, as I mentioned before, the colleges and the university are in keeping with wanting to make sure that appropriate material is that would be possible, and I think most of the colleges and the districts would be amenable to that.
Thank you.
Seeing nothing more, Mr. Hutcherson.
Good morning, Mr. Chairman, members of the committee. My name is Grady Hutcherson. I am the Executive Director for the Wyoming Education Association, and I'm a 24-year educator in the state of Wyoming. And I'll keep my comments very brief. I do not have the version of all of the amendments, but based on the conversations that you all have had, the number of questions and concerns about this bill are what I want to echo as well. The unintended consequences by removing the section that Dr. Moritz just referred to is extremely concerning to me. If you are a health educator and have health standards that you're required to teach, this version of this bill currently then raises the question of whether or not a health educator could potentially be fined and or imprisoned. So I know you all have brought up the concerns about unintended consequences. I want to reiterate those concerns that we have as well. Thank you, and I would stand for any questions.
Mr. Hutcherson, do those health ed classes require an opt-in by the parents? Would that be an acceptable balance point, that those classes be opt-in only?
Mr. Chairman, I'm reluctant to answer that question because I'm not certain if there are districts where that is required or not. I know the state health standards are expected to be taught by all educators in the state of Wyoming.
Thank you. All right. Welcome.
Chair Washut, representatives, good morning. My name is Katie Medill. I'm the mother of 2 public school children and a proud public educator of almost 20 years in Sheridan County. I'm grateful for this opportunity. Thank you. I'm going to voice my concerns with House Bill 194. I think it is an unnecessary government overreach. It would be wrongly assumed that one who speaks against this bill would be somehow in favor of promoting or allowing youth access to obscene or harmful materials. Of course, nothing could be further from the truth. I do not want my children exposed to materials that I consider to be obscene or harmful. And thankfully, as a parent, I already have the rights and abilities and responsibilities, as it was mentioned earlier, to monitor and control this. It was to avoid redundancy. I'll skip the part about the public library, and I'll go to the fact that my children attend a Wyoming public school district where I, as a parent, can opt them out of any school library or curricular materials that I deem inappropriate for them. And the school district and the professionals it employs are bound already, appropriately so, by numerous lengthy policies and guidelines intended to protect children and uphold parental rights. After all, parents and guardians should be the deciding factor on what their children should or should not read, not the state. In other words, these guardrails already exist, in my opinion. Although House Bill 194 might seem to satisfy the issue of public library and students, children perusing materials, as was mentioned, I still think it's unnecessary. It's not really about protecting children. I think it's about exerting unnecessary measures of control over public education. I think it devalues, in fact, it threatens to criminalize public educators. And like too many other proposed legislations, it positions educators as people to protect children from, rather than the highly trained, certified, licensed professionals who chose the noble endeavor of educating children and continue to choose it, despite the barrage of legislative measures that rebuke and vilify them, such as this House bill. In summary, as a parent, I think this bill is unnecessary. As an educator, I think it's concerning, given the conversation that's already been happening, and quite frankly, offensive. Thank you, and I'd be happy to answer any questions, Chairman.
Appreciate you being brief, to the point. Questions? Thank you. Next.
Thank you, Mr. Chairman. My name is Chelsea Collier, and for the past 3 years, I've served on the Campbell County Public Library Board in Gillette, Wyoming. I'm also an educator. Currently, if I, as an adult in our community, give a minor one of these sexually explicit books, I can be charged with disseminating obscenity to children. If a librarian or an educator does the same act, they walk away scot-free. This loophole has allowed our liberal media outlets and publishers to promote sexually explicit material to minors without oversight of parental consent other than a library card. A library card that some say they get as young as 3 years old. You know, it's pretty exciting to get your first library card. Parents have no clue what materials their children will have access to when they are old enough to spend time browsing the library to find a just right book and stumble upon these acts displayed in pictures, drawings, and through graphically, erotically painted words. Parents for decades have seen the libraries as a safe place for minors, but they have not truly seen what has seeped into our walls and pages. We have had countless accounts of people who come to our meetings not understanding what fully is in these books. They are angry about their encroachment on their freedom to read, and yet when shown exactly what these stories hold, they are aghast at what these books hold. Who could write something so horrific, they say. How could they put these into words and ever let someone else read it, they say. I have read these books that are teaching children through fiction and nonfiction text about firsthand accounts and fantasy stories, about the many exploratory options for sex acts and how they can, quote, be enlightened. Many say these books are educational, and I tell you as an educator, they are not. These stories contain sexually explicit information directed at minors that causes you to be filled with feelings no minor should ever feel. Some will say this helps those who are abused. I don't think reliving your trauma and triggering a person is a way to help them. It just creates victims, reopening old wounds for those who cannot find steps to healing. Some will say these books educate those whose families aren't educating them. And time after time, we see children act out and play what they read, see, and hear. We do not need to expose minors to more information than they are mentally ready for. Finally, another argument pleads that minors can already get this information with the devices in their pockets. Yes, I know, they say they can get it on the internet, but it doesn't need to come from my taxpayer dollars. Please, I advocate for our library boards and your school libraries and push forward with House Bill 194. Thank you, Chairman, and I'll stand for questions.
Thank you. Seeing none, appreciate your testimony this morning. Next.
Thank you. My name is Jana Kestner, and I appreciate you all letting us here today to speak. I am a parent from Laramie County School District Number 2, so just to the east of Cheyenne. I wrote up a little bit that will kind of cover what's already been said by some concerned parents and educators, and I'd also like to add a little bit to that. Overall, though, I am asking you to kill House Bill 194. This obscenity bill, in reality, is a book banning bill, and it will have far-reaching and unintended consequences, which I believe some of you pointed out in some of your questions earlier on. If passed, it will have impacts not just in what books are available in our libraries, but how our teachers are allowed to teach. This includes sex ed, health in general, English classes, psychology, and a dozen other disciplines. For example, history teachers would probably get in some pretty dangerous waters, as was already brought up by Representative Singh, if they showed images of the Holocaust or World War II. And those are very important parts in our history that we really need to be able to teach and not edit. And I do believe that high school students are able and mature enough to see those images to understand what happened, almost 100 years ago now. And it is also important to note that colleges do have high school students in them, sometimes as young as 15 or 16. And to ask community colleges and universities to have to monitor and oversee making sure that we don't have a minor in our class that, somehow you could get in trouble for it, I think we could get into some dangerous waters there as well. Teachers and librarians would become targets for criminal prosecution under this new statute, just for anyone who felt offended by something that was found in a library or that was presented by a teacher. Censorship would become very, very common. More books would be banned out of fear, and no one who bans books is on the right side of history. I think we've seen that in the past. Teachers and administrators would face frivolous lawsuits and harassment, and this would tie up vital funds and time for both our educators and our school districts. Local control and policy would fly out the window, as we'd be all bound by the whims of the state government, or Big Brother, if you will, when it comes to this particular bill. This bill would also significantly contribute to Wyoming students falling behind their peers nationwide. If all of this material that we do use to teach, and please be aware again that these people who are teaching, both in our libraries and our school systems, they are trained professionals. They know what to do. Yeah, there's bad eggs everywhere, but that they are not in the majority in any way, shape, or form. They're the very small minority, and we have means to take care of those instances of abuse if they happen. So I worry that Wyoming would fall behind the nation when it came to education. And finally, since parental rights seems to be kind of a buzzword this legislative session, let me say this. Parents do already have the ability to request teachers and librarians to limit what their child sees. Please don't take away my parental rights or the majority of parents just to appease a few who exist within our community who would like to have others control what is being said. I trust our librarians and I trust our teachers to do the right thing. And as a parent, if I need to get more involved, I already have the means to do that. So thank you for your time today.
Thank you, Representative Singh.
Thank you, Mr. Chairman, and Ms. Kestner for being here today. I take the consideration of any sort of banning of books very seriously. Would this legislation prohibit the sale of these materials on the free market?
Ms. Kestner.
Like others, I don't know, but I could see there being some gray waters there with how you distribute material or even giving away materials. I really don't know how that would work, for example, with a community garage sale, if you were selling some books that were perhaps questionable to some. I don't know. But I do worry that this bill does have those far-reaching and unintended consequences that could be very detrimental to us.
Okay, thank you very much. We passed the 9:30 mark. We keep moving on point. Next.
Thank you, Mr. Chairman, for allowing me to express my support of this bill. I am a school board trustee and a parent of
You
two high
state your
school-
name for the record, please.
I'm sorry, my name's Mary Schmidt, and I'm from Natrona. I am speaking on behalf of I am not speaking on behalf of my board, I'm speaking as an individual. But I can say that our school libraries do contain many of the graphic novels that contain nudity, language, and many other obscene things. In light of our recent NAEP scores that show 70% of our fourth graders and 71% of our eighth graders are not proficient in reading, this bill will encourage school boards to review their library resources and hopefully encourage policies that would direct school libraries to support the academic studies instead of titillating leisurely reading materials that we currently have. I would also recommend that you designate the school board and the school board trustees or the public library board as the authority for review of any challenges from parents or from the public that was mentioned at the end of the bill. And just to address a couple of your other concerns that you guys have asked, sex ed classes do require parental notification to be taught to their students. The BOCES program, which I am a board member of, we can always add to the parental consent forms that your child could be exposed to some of these materials. That wouldn't be an issue. And as far as the one question of would this prevent any of the purchase of these materials on the open market, it wouldn't. It does not prevent the publishing houses. It does not prevent public school or bookstores from selling these materials. It is purely, and intent is directly targeted at the schools and at the libraries where children can come in freely and peruse or access books. And these books are not, as far as the school library goes, they are not adding to any of the academic studies that we teach in any public school in Wyoming. And so therefore they shouldn't really be there. We don't have infinite resources, so we should be focusing on what our studies are, not on titillating reading, leisurely reading. Thank you, and I'll stand for any questions.
Thank you very much, Ms. Mead. Next.
Thank you, Mr. Chairman. I'm Sage Bear, and I currently serve on the Campbell County Library Board. I have been dealing with this issue for the past 3 years, and we have written a policy to move the books that are sexually explicit from areas that are designated for minors, and we've heard arguments on both sides. But one thing is for certain, behavior is changed by exposure. Many teens start experimenting with sex before the age of majority. However, sex has long-term physical and emotional consequences, but it is an adult topic. Just as tobacco is not to be sold to teens, neither should the government be providing sexually explicit material to minors. Similarly, minors need parental permission to view a rated R movie. They should also have to have parental permission to read sexually explicit books. Librarians are taught that they can't make judgments about books. The American Library Association says they're not lawyers, and only the courts can determine what is or is not obscene. We need a clear definition in our statutes that defines sexually explicit acts, whether in word or in visual format, should not be curated or marketed to minors by anyone. No interpretation needed. Also understanding that libraries don't know everything that is in all the books in all the libraries, a review period once a book is discovered is appropriate. However, once the library has been made aware of the offense, they lose their exemption and are subject to fines. As mentioned earlier, my community has already set forth a policy. We have moved books from the teen and children's sections to the adult sections of the library. However, the digital library, the audio books and the Kindle books are purchased in a consortium through the state library. The state library catalogs and markets those materials to the teens or on the market, taking away the local control that we supposedly have. Let's be honest, how these kids are reading their books on their devices. This is a state issue. Protect our youth from being exposed to material they are not ready for. Thank you, Mr. Chairman.
Appreciate the tight, concise testimony. Representative Lean.
Thank you, Mr. Chairman. Thank you for being here today. My question is, in the amendment, it says a 60-day review period. Do you feel that is adequate, too long, too short?
Ma'am.
I believe that's adequate. I mean, you don't want 30 days because, people are on vacations or whatever, and you meet every so often and anything, but so I think 60 days is a fair time period.
Thank you. Next.
Thank you, Mr. Chairman. I'm Anita Marple from Fremont County. I am a Christian.
a conservative, and a former homeschool parent of 2 grown children. My daughter's working on a PhD in Michigan, and my son is an active duty officer in the United States Air Force. I am also the library director of the Fremont County Library System, and I'm here to urge you to vote against House Bill 194. In Fremont County, this has been a hot topic, especially in 2024. So this issue has been part of my personal and professional context for a couple years. It's an emotional topic, but we need to approach this rationally. I don't doubt that the sponsors of this bill seek to prevent harm to our children. Speaking as a librarian and as a parent who raised my children going to the public library, so do librarians. However, I feel the whole context of this issue has been characterized by misinformation, wrong assumptions, false conclusions that have led to the creation of this bill that seeks to criminalize librarians in conducting our duties. In the current Wyoming statute, the core legal decision, as has been mentioned, is from Miller versus California, in which the US Supreme Court established a 3-point test for defining obscenity. And it doesn't say adult obscenity, it just says obscenity. In my library system, this 3-point test is part of our policy and procedure for collection purchasing. In our work, we are already constrained by this law. Furthermore, for decades, we have had a process for any individual to request reconsideration of any material in the library collection. Every public library system in Wyoming has a process for reconsideration. During the 7 years I've been in leadership in the Fremont County Library System, only 4 individuals have submitted requests for reconsideration of library materials. This bill would allow individuals to ignore policy and procedure established by local governing bodies and bring criminal charges against the library system and myself because they object to a certain book in the library, or perhaps because they have a personal grudge against me. Now, there are some amendments that have been proposed, but here is still a problem. In the current statute, a point of disagreement raised by the Miller test is the definition of community standard. The US Supreme Court only went so far in Miller versus California because it recognized a variety of opinions on this issue. There has to be room for nuanced discussion for what is obscene. In my community, there is disagreement. I believe the current statute preserves space for disagreement while providing a sufficient guideline for those of us who deal with these issues in the course of our work. The bill seeks to define the community standard for the people of Wyoming. But I must point out and vehemently object to the fact that this definition was created by only one group of people in our community. Have the sponsors of this bill included employees of schools, colleges, universities, museums, and public libraries? Among my public library colleagues, the answer is no. So it seems we have one group, one point of view seeking to define the community standard. This is undemocratic in a society that constitutionally protects a plurality of views. And as a Christian librarian who has assisted hundreds of individuals, families, and young people through my work in the public library, I object to the creation of lawfare to harass and intimidate me into making choices that will most assuredly trample on the free speech and equal protection rights of people in my community. It's an emotional issue. It's an important one. I think the statute as it currently stands is sufficient. I don't think there's been enough discussion with enough variety of opinions on this topic to proceed with changing the law. So I think the proposals in this bill are not democratic. I think they're harmful. And I appeal to you to vote no and not participate in the creation of lawfare. And consider this, we all talk about the slippery slope. So I feel like this is a leap onto the slippery slope. What will be next? Shall we start debating what are dangerous political ideas that should be excluded from our libraries? Should we start examining what are dangerous religious views that should be eliminated from our libraries? Please consider these things. Thank you for your time. I stand for questions.
Thank you, Ms. Merkel. All right, next. State your name for the record and direct your comments to the chair.
Thank you, Chairman. My name is Jennifer Hopkins. I am a wife, a mother, grandmother, and a school board trustee in Natrona County. I do not speak on behalf of the district today. 4 years ago, it was brought to my attention that there were books with obscene content in Natrona County's district. I went to the school board, librarians, and authorities, but nothing would be done about removing such books. It was discovered schools are exempt. The only change in our district currently is that we have an opt-in list. However, not all the books make it onto that list for various reasons. It's not just the school board library where you can find inappropriate books. Such books are being used for classroom study, and you can go into a local you can't go into a local library without coming across an obscene book. This bill holds adults and our children's lives accountable. With this being said, I am also I'm a breastfeeding advocate. I would request adding clarifying language to help mitigate some unintentional consequences regarding public health education, particularly in areas such as lactation education, breastfeeding classes that could involve minors. I suggest the exemption to maybe look like community-based health education or support services delivered by qualified professionals or trained peer counselors, materials or instructions reasonably necessary for public health, promotion, or education. I hope this would better cover any situation concerning breastfeeding. Thank you, and I stand for any questions.
Thank you, Ms. Hopkins. No questions. We have some people waiting on Zoom. I don't want them to feel like we've just completely ignored them. So let's bring in Mr. Butler. Folks, we're at 9:45, so we have 15 more minutes, especially if you have things to add that are not redundant to testimony we've already heard. Let's bring in Mr. Butler.
There we go. My name is Charles Butler. I live in Gillette, Wyoming, and I am presently the chairman of the Campbell County Public Library Board. And we have been dealing with this, as you know, for many years. I speak in support of this bill. Protecting minors for age-appropriate material has become a nationwide controversy. This legislation seeks to protect our children from being exposed to information, which countless studies have demonstrated that can impact and be unhealthy for minors. Such exposure can lead to confusion, anxiety, and unhealthy perceptions. What we're talking about is legislation to help guard minors from sexually explicit material in publicly funded libraries. Libraries are an invaluable resource. They open the doors to knowledge and creativity and imagination. Yet they also hold the responsibility, more importantly, to protect our valuable children. When children and teenagers browse through the aisles of local libraries, they deserve to find books that are inspirational and educational, not materials that expose them to content that is inappropriate for their age. Parents need assurances that our community and legislatures are advocating for protecting minors from this material. Some may argue that advocating for this legislation equates to censorship or book banning. This is misinformation, and it is furthest from the truth. This narrative is often pushed by organizations such as the American Library Association. We're not calling for the removal of books or the suppression of ideas. Instead, we're advocating for establishment of guidelines that prioritize the well-being and development of our youth. We want to ensure the literature that is available to them is age appropriate and does not contain material that is harmful to their emotional or psychological health. This is not limiting access to information, it's creating a nurturing environment. Passing this bill, House Bill 194, and committing to protecting our children from exposure, they may not be developmentally ready to comprehend and to ensure that our libraries remain a place of discovery and safety. Parents are looking to us for support for this. Together, you can create a future where the knowledge is accessible, and together we can dispel the myths surrounding book banning issue and censoring information. Please, I do urge you to make the amendments that need to be addressed, but put this in the forefront of your thoughts. Thank you. I appreciate it, and I will stand for questions. Hold on, I don't hear you, so I can't hear you, so something's going on. There we go. I'm sorry, something got muted. Are you there? Oh. It says you muted me. Nope, sorry. I guess you can move on. I can't hear anything.
The Albany County Public Library is one of the oldest county libraries in our nation. And it has a long legacy of local control in its governance and in its operation. And it means more than a concept. And for us on the board of the Albany County Public Library, it's really innately important to the way the library completes its mission in our community. And so today I've heard that and I just want to speak to library boards work, and they work because they gather ideas around community standards. And so we have processes in place. And this bill, HB 194, creates an unnecessary burden on what's already working. So we have policies around materials development, and we work closely with librarians to develop that. We also put that out there for public comment, and people can come to the table to look at the policy when we revise it and when we continue to make it better. We also have policies internal that the board revises and works with the library staff around challenging materials. If you're a parent and you see something in the library, you have a process that's clearly articulated in terms of challenging that material. And all of those things are in place, and your opportunity is there to exercise your parental influence in what your child is seeing. And lastly, I work with librarians that amaze me in terms of their professional skills. Working on my third term, I didn't know all of the ways that libraries work. It's a really complicated system. We have trained professional librarians because it's a profession that requires a lot of information, a lot of skills. This bill, with its punishment, sends a horrible message to our young people and to our librarians in terms of the everyday completion of their jobs. And so I would like you to vote no on HB 194, and I stand for questions. Thank you very much.
Thank you very much, ma'am.
Hi, I am Christine Brady, and I'm the director of the Goshen County Library. And like many of you, I wear more than one hat. I've been a homeschooling mom, I'm a pastor's wife, I serve on many boards, and I care about my community and my library. And I want to speak to one thing very quickly, this idea of restricting access. I just told you, I'm in Goshen County. It's small. I have a small staff, I have a smaller budget, and all of our books are in one big room. How am I going to restrict access? We have things in different locations, but let's be clear. It is a parent's responsibility to know where their children are. Children don't just wander into libraries. The parents are supposed to know where their kids are. My job is to provide access to information for my community. My job is to provide a place where people can engage in ideas. Sometimes my job is to provide a warm place for people who don't have heat. And so trying to figure out logistically how a small library is going to restrict access is going to be a difficult task. I urge you to vote no on this bill.
Thank you very much for your concise testimony. Ma'am?
Thank you, Chairman, members of the committee. My name is Patricia McCoy, and I am here to testify today in support of House Bill 194. My testimony comes from a place of deep personal pain, but also hope that we can prevent other families from experiencing what mine did. In 2018, my bright athletic daughter entered high school and joined the speech and debate team. Like any mother, I was thrilled to see her following in my footsteps. However, what began as an opportunity for growth became a nightmare that nearly cost my daughter her life. Despite my clear parental opt-out directives, school staff deliberately exposed my daughter to materials that violated our family's religious beliefs and values. They didn't just ignore my wishes as a parent, they actively undermined them. When I raised concerns, I was dismissed as ignorant and uncomprehending, but I understood all too well what was happening. Trusted adults were secretly providing my daughter with gender transitioning materials, including a chest binder that caused physical harm. Over 2 devastating years, I watched helplessly as my once vibrant daughter slipped into severe depression. Her grades plummeted, she withdrew from friends, and the light in her eyes dimmed. When I sought help from school administrators, they treated me as an enemy rather than a concerned mother. Only one counselor took my concerns seriously, but even she felt powerless to intervene. Then came the phone calls that haunt every parent's nightmares. My daughter had attempted suicide, not once, but twice. The very institutions meant to educate and protect her had pushed her to the brink of despair. This bill isn't about limiting education or expression. It's about protecting children from harmful adult agendas and preserving parents' fundamental rights to guide their children's development. The current exemptions for schools and libraries have created a dangerous loophole that allows some staff to expose minors to inappropriate material while shutting parents out completely. By supporting House Bill 194, you can help ensure that no other parent has to watch helplessly as trusted institutions systematically undermine their child's well-being. No other daughter should have to reach the depths of despair that mine did before getting help. Through God's grace and intensive support, my daughter has begun to heal, but many children are not as fortunate as her. I urge you to vote yes on House Bill 194 and close this loophole that enables schools to bypass parental rights and expose children to harm. Thank you.
Thank you, Ms. McCoy. So as I said earlier, the committee has to be on the floor in 3 minutes, so I'm going to close public comment. I apologize that you're not going to be able to testify today. I hope everyone agrees that we've heard a nice cross-section of opinions, both for and against this bill. I've done my best to be as fair as possible to hear witness testimony today. We will take the bill up on Wednesday for committee action, but public comment has closed. Representative Chestick, one comment?
Yes, one comment. I hope we can encourage those who weren't able to testify to at least provide us with some written emails or written testimony about what you would have said. Thank you.
Very good. And with that, we are adjourned for today, and we'll meet again on Wednesday morning.